Hello, this is attorney Brian Pendergraft, and this video is a part of my Maryland Real Property Law YouTube series. And today I will be covering Maryland Real Property Code Section 8-216. And that is the law on the prohibition of non-judicial evictions by lockout or willful diminution of services by landlords. So this is a statute that requires landlords to go to court in order to evict tenants. Landlords cannot just lock out non-paying tenants. They have to go to court in order to do so. And they can also not willfully diminish their services in order to try to get them to move out. So what that means is that they can't just cut off a tenant's water or cut off a tenant's electricity or other utilities in order to try to get them to leave or to try to make their, the tenants' lives miserable in some way that I haven't covered. Even if the tenant is also not paying rent, you're not allowed to do that. So Maryland Real Property Code Section 8-216 is what codifies what I just said into law. And that's what I have pulled up in front of you right now. And I linked the law in the description of the video in case you want to follow along. It'll take you to the page that I'm on right now, except as you can see, I've color coded mine. But I color coded mine because I think that I like to group together the ideas, and I think that it makes my videos easier to follow. So that said, here's a few disclaimers. Although I am an attorney, this is legal information. This is not legal advice. So if you would like legal advice, you can contact a Maryland real estate or landlord-tenant attorney. If you would like to hire me or consult with me about an issue, I've included my contact info in the description. Also, this video was taken on November 19th, 2019. So it's possible by the time you watch this video that the laws may have changed. So be sure to visit that link in the description and see if anything has been updated. And please like and subscribe if you want to see more content like this. All right, so let's get into it. So we're starting with this pink purple section here. So this is 8-216A. All right, so the statute starts by giving you definitions. So here's how they define. Let's see exactly what they're defining. Let's get into it. So A1, in this section, the following words have the meanings indicated. All right, so 2, threaten to take possession. So here's what it means to threaten to take possession. So here's what it means. All right, let's see. It means using words or actions intended to convince a reasonable person that the landlord intends to take imminent possession of the property in violation of this section. Okay, so that is what a threat to take possession means. So if a landlord displays words or actions that make it that a reasonable person would think like, hey, he's trying to, he's trying to take possession without going to court. That is what it means to threaten to take possession. All right, so what is willful diminution of services? So that means intentionally interrupting or causing the interruption of heat, running water, hot water, electricity, or gas by the landlord for the purpose of forcing a tenant to abandon the property. So essentially, you cannot. So heat, running water, hot water, electricity, gas. Those are essentially, let's just say utilities. All right, so willful diminution of services means intentionally erupting or causing the interruption of utilities. It's probably an even to try to get the tenant to leave the property. So you can't, again, as I was saying earlier, can't just threaten to cut off electricity in order to, try to get, or you can't just cut off electricity and say threaten. You can't just cut off electricity in order to get your tenants to leave. You can't do that, or water or any other utilities. All right. And let's see. Willful diminution of services does not include. Okay. So this is not the willful diminution of services. I should point out, I moved down to 3-2 now. 3-2 eyes here. So willful diminution of service. So it does not. So here's was not the willful diminution of services. So it does not include a landlord choosing not to continue to pay for utility service for residential property after a final court order awarding possession of the residential property, if the landlord has provided the tenant reasonable notice of the landlord's intention and the opportunity for the tenant to open an account in the tenant's name for that service. This is saying, so after you take a tenant to court and you get a court order for possession. So let's say your tenant's not paying rent, and then you get a court order for you go to court, you win your federal rent case, and after that you are able to, let's say, cut off, let's say, the water, but only under these circumstances. So you have to let the tenant know. You have to give them notice that, hey, I'm cutting off the I'm going to be cutting off the water, or I'm not you're not or I'm not paying for this water anymore. um you know what, I should probably word that better, actually. So the way that the statute reads, it doesn't say that a landlord, it doesn't even necessarily say that a landlord can cut off utilities. It says choosing to continue to not pay for utilities. All right. So essentially, yeah, I may want to take back everything that I just said, because a landlord, at least the way that I interpret this, all right, this is getting kind of interesting, because the way that I interpret this willful diminution of services now is that a landlord still cannot actively cut off a tenant's utilities after they get a failure to pay rent or any form of judgment for possession against them. Let's say they can do that. It says that they can continue to shoot. They can, after they get that judgment, what they can do is not pay. So I guess it's up to the utility company to decide whether they're going to cut off the whether they are going to cut off that utility or not. But yeah, so I'm not sure if you notice that, if you get that distinction there, but if you don't, go ahead and shoot me a message. But I would still, the way that I interpret this statute is that landlords, they can't just call the utility company and tell them to cut off the electricity after the failure to pay rent case. But what they can do is they can decide not to pay the electricity, but what they have to do is they have to give the tenants some reasonable. If they do that, they have to give the tenant reasonable notice that, hey, I am not going to be paying the electricity bill anymore. Not I got a judgment against you, but I'm going to give you, here's your reasonable notice of that. And you need, now you have your opportunity, where I got to give you an opportunity to go and put that bill into your name if they would like to continue those services. All right, so moving on to this red section here. This is section B1. Except as provided in paragraph 2 of this subsection, a landlord may not take possession or threaten to take possession. Again, those are those definitions up here earlier. So they cannot threaten to take possession. They may not take possession or threaten to take possession of a dwelling unit from a tenant or tenant holding over by locking tenant out or any other action, including willful diminution of services to the tenant. Okay, so this provides exceptions. Except it's provided in paragraph 2. So this is all right. So in paragraph 2, it says when they are allowed to take possession from a tenant or a tenant holding over. So let's move down to 2. All right. So under what situation? So this essentially says what I said earlier. Landlords are required to go to court, but a landlord may take possession of a dwelling unit from a tenant or tenant holding over only if 2I, in accordance with a warrant of restitution issued by a court and executed by a sheriff or constable. Again, so that's saying they can take possession if they go to court, prevail, win, and then file a warrant for restitution. Or 2I, the tenant has abandoned or surrendered possession of the dwelling unit. So in the case of abandonment or surrender of possession, a landlord is, or they've surrendered possession of the dwelling unit, then the landlord is allowed to go in and retake possession of the property. All right, so moving on to C, this green section here. So C1, if in any proceeding the court finds in favor of the tenant because the landlord violated subsection B of this section, the tenant may recover actual damages. So actual damages are those are damages that the tenant has actually suffered. So we would have to essentially, it's the measurable damages, it'll be based on the damages that they've actually suffered, but it doesn't say, like, let's say punitive damages, for example, that's over and beyond what they've suffered. But again, here they can only recover actual damages. So let's see. 2, reasonable attorney's fees and costs. So the tenant decides to sue you because the landlord has willfully diminished their services, they can recover their reasonable attorney's fees and costs as well. Alrighty, and 2. All right, here the remedies set forth in this subsection are not exclusive. So what that means is that, okay, so you're not I guess, limited to these remedies here. So there may be more remedies. So maybe I should take back what I said about punitive damages earlier. So it's just not covered in this statute, but there may be other laws or other theories or other grounds where perhaps you can go after different kinds of damages, maybe even punitive damages, like I was saying earlier. Um, so moving down to D, this blue section here. The section may not be construed to prevent a landlord from taking temporary measures, including changing the locks to secure an unsecured residential property. If the landlord makes good faith attempts to provide reasonable notice to the tenant, the tenant may that the tenant may promptly be restored to possession of the property. So, in other words, a landlord they're still allowed to attempt to secure their properties. Let's say they think that I don't know. They think that the tenant has abandoned the property, and they don't know for sure or not. So, what they would like to do is secure their property. So they may change the lock, and they can do their best to provide the tenant notice essentially. And but the tenant essentially was saying that the tenant can't come back around and say, hey, you've after, let's say, appearing to have abandoned the property or disappearing for whatever they're doing, they can't just come back and just be like, hey, you've try to sue under the statute and then say, hey, you've illegally locked me out, or what that wasn't the case. So landlords are still allowed to protect themselves or protect their properties, and to do that as long as they try to send the proper reasonable notice. And and to go a bit further is that if the tenant does come back, it looks like here is that what they should try to do is restore possession of the property to the tenant as well. So that looks like how the tenant how the landlord would stay out of hot water and violate the statute. That's it. That's it. So hopefully you liked the video. Please like and subscribe. Hopefully I wasn't too confusing. I felt like I may have been a bit confusing when I got to when I was trying to, I guess, better describe willful diminution of services here. But hey, you know what? Like I said, man, I do these videos off the top. So, I'll do better on the next one, I guess. Anyways, so please like and subscribe, and my information is below. And thanks for watching. All righty, take care.